This meeting will come to order. Today we have a hearing entitled Institutional Review Boards that oversee experimental human testing for profit. The chairman, ranking member, and chairman emeritus will be recognized for 5 minutes for opening statement. All other members of the subcommittee will be recognized for 3-minute opening statements. I will begin. Experimental medical testing on human beings has a troubling history. From the atrocities perpetrated by the Nazis in World War II to the infamous Tuskegee study in the 1970s when subjects were denied treatment for syphilis, we have learned that we need strong controls in place to protect the health and safety of people who participate in medical experiments. Under current federal law, medical testing of human subjects that is federally funded or relates to federally regulated drugs or medical devices cannot proceed without the approval of an institutional review board, a panel of doctors, scientists, and non-scientists charged with ensuring the health and safety of the people participating in the study. Our committee began investigating IRBs in 2007 when we learned that Copernicus IRB allowed the study of an antibiotic Ketec to continue without examining reports of fraud it had received. As part of our continued investigation, we asked the Government Accountability Office, GAO, to conduct undercover testing of the IRB review process. We wanted to know whether IRBs are rubber stamping research studies, whether clinical researchers are IRB shopping, or choosing IRBs based on how quickly and how inexpensively they approve studies, and whether government oversight of IRBs is adequate. Today we will hear the results of GAO's investigation, and they are not reassuring. GAO will explain how Coast IRB, a for-profit company, approved a fictitious study led by a fictitious doctor and submitted by a fictitious company. It called for a full liter of a fictitious product. In fact, the same amount in this bottle here to be poured into a woman's abdomen cavity after surgery, supposedly to help healing. GAO's fake protocol was based on an actual high-risk study for a product that the FDA ultimately withdrew from the market because of deaths and infections among patients. Besides Coast IRB, GAO also sent its fictitious study to 2 other IRBs that they both rejected our proposal out of hand. Here are some of the things the 2 other IRBs said after reviewing the fake GAO study. The experimental design was the most complicated thing I've ever seen. Doing a surgery, a major operation on a patient, then a mystery guy walks in and dumps the solution in the body. Where is the safety for the patient? It appeared that people were just going to go out and start injecting. We realized it was a terrible risk for the patient. It's the worst thing I've ever seen. But Coast IRB approved the protocol unanimously, 7-0. The doctor with primary responsibility for reviewing the study told other board members that the protocol looks fine and that the substance to be injected in the abdominal cavity was probably very safe. Nobody at Coast IRB ever reviewed any of the data cited in the proposal to support those claims. If they had, they would have discovered it did not exist. The doctor who reviewed the study did raise a question about whether the study's claim was accurate and that the substance had been approved previously by the FDA. But no one ever followed up with the FDA to answer this question. And in an email to the rest of the board members, the doctor stated it would not have made any difference, that he would have approved the study anyway, and that the lack of FDA approval won't affect my recommendation. The board chair told us she relied on this recommendation and voted to approve the study even though she did not read the full protocol. Why was this review so shoddy? The evidence suggests that Coast was more concerned with its financial bottom line than protecting the lives of patients. According to Coast CEO, who will testify today, Coast had a practice of voting on research protocols within 48 hours of the board receiving them. One of the testimonials that Coast sent to prospective customers reads, "Thank you very much. You guys are the quickest IRB I ever worked with, and I've done this 7 years." Coast even sent a coupon offering to give free IRB review so researchers could coast through your next study. After this committee wrote to Coast IRB requesting documents associated with their approval of this fictitious study, Coastal officials took pride in that they were able to discover the study was bogus, but this was 5 months after they approved it. Coast CEO, Mr. Duber, told our staff within seconds they were able to determine that this was not an actual medical device, and within 4 to 5 hours, they determined that this was a sham. Had any of his staff done the research before they approved our bogus protocol 5 months ago, Coast IRB would not be testifying today. GAO's investigation also exposed other problems with the IRB system. GAO was able to create a fictitious IRB that it registered with the U.S. Department of Health and Human Services, HHS, with no questions asked. The president of this fake IRB was this dog, Trooper, who is sadly now deceased. Trooper didn't know anything about protecting human testing, but for a 3-legged dog, he sure could catch a Frisbee. GAO created a fake website for Trooper's IRB called Maryland House. They received real inquiries from real researchers and actually had one research protocol submitted for review. When asked why it selected GAO's fake IRB and Trooper to conduct its study, a research coordinator stated that it was because of the low price and a quick turnaround time. GAO's findings raised serious questions not only about specific IRBs involved in this investigation, but with the entire system for approving experimental testing on human beings. As a society, we have a moral obligation to ensure that human testing is done in the most responsible and ethical manner. I look forward to the testimony today, and I hope we can discuss ways for both government and industry to fulfill its obligation. That concludes my opening statement. The next call to the ranking member, my friend Mr. Walden, for his opening statement, please.
Thank you, Mr. Chairman, for convening this hearing. It's another example of kind of investigative work that's possible when we work together in a bipartisan manner, as we most always do. Subject to this hearing, the oversight of human subjects in clinical trials by institutional review boards, or IRBs, grew out of a drug safety investigation in the last Congress. Working together, we identified what we thought might be problems in IRB oversight of clinical trials. We made a joint request to the Government Accountability Office, the GAO, to take a closer look into what was going on. Now we're here today to learn about the results of that investigation. As we meet today, literally millions of Americans are engaged in clinical trials taking place in more than 350,000 locations across America. Right now, people who have volunteered for these trials are walking into a doctor's office or a hospital or some other setting, and they're taking experimental medicines or allowing new devices to be used on their bodies so that scientists and doctors can determine whether and how a new treatment will work. Without their willingness to volunteer for a trial, all of us would not benefit from the new drugs or devices to treat illness and disease. But they volunteer believing that an independent, government-sanctioned process is reviewing the protocols and products to maximize their safety. And I have to tell you that after reading the report of the GAO that explains how easy it was for the undercover investigators to fake their backgrounds and get approval for human trials and create their own fake IRB, something is horribly wrong. And Mr. Duber, I've read your testimony for today, and I find it to be the most pathetic example of trying to spin your way out of taking responsibility for a serious approval error I've ever seen. The fact that your board unanimously approved this fake company to run fake tests using a witch's brew recipe for a gel that doesn't exist, I find to be outrageous. 2 other IRBs rightfully rejected the application, saying the plan was awful, a piece of junk, and the riskiest thing I've ever seen on this board. So why did your company unanimously approve it? And would you want your family members to participate in a trial using this gel? No, rather than discuss how your board reached unanimous approval and said the gel is probably very safe and that a risk assessment is not required, you chose to attack the investigators and even call this oversight effort tyranny. Well, sir, your approach is misguided. It reminds me of the old ruse used by parents on their children to draw attention away, going, "Look, bright, shiny object." Well, I don't care how many bright, shiny objects you tell us to look at in your PR firm and your lawyers to draw attention away from the real issue. Your company still has to answer for this decision that would have allowed patients to spend 5 months taking a fake and potentially lethal product from a fake company with a fake doctor. And to HHS, What in the devil's going on in your agency that allows you to think you can ignore the law and regulations regarding adequacy of IRBs and simply enter whatever is emailed your way and put the U.S. government stamp of approval on an IRB? You have 3 federal employees signing up 300 new IRBs a month, according to the GAO, and the leadership of this agency says it's not important to follow the federal rules regarding a test of adequacy. Nobody picked up on names like fake medical devices, April Fools, Timothy Witless, and Alan Ruse, or the town of Cheatsville, Arizona. This didn't raise a flag, and yet you give out the HHS stamp of approval. It's unbelievable. Moreover, it could be lethal. Is it any wonder the GAO says this system is vulnerable to manipulation? I understand that more than 10 years after the Inspector General's report, FDA recently announced a final rule with respect to the IRB registry system that will go into effect this summer. I'm curious whether our witnesses believe this new rule will address any of the problems we'll hear about today. It is our solemn duty to ensure that those who participate in clinical trials can have confidence that their safety is in trustworthy hands and that the government certification means something. We want to encourage participation and support of clinical trials by protecting the integrity of these studies and strengthening the public trust. Thank you again, Mr. Chairman, for convening this hearing. I look forward to today's testimony, and I yield back my time.
Thank you, Mr. Walden. Mr. Gett for an opening statement. 3 minutes, please.
Thank you, Mr. Chairman. Mr. Chairman, patient safety in research situations for this subcommittee is really like food safety. One thing you can be sure of is that a crisis is looming just around the corner. In 1999, a young man named Jesse Gelsinger died while participating in a gene therapy trial at the University of Pennsylvania. An FDA investigation concluded that scientists involved in the trial, including the lead researcher, who had a potential financial interest in the results of the trial, broke several rules of ethical conduct, including inadequate informed consent procedures. In 2006, the antibiotic Ketec caused liver failure and death in patients who used it. An investigation showed that investigators had given fraudulent data to the FDA to gain approval of Ketec. A whistleblower who learned of the fraud contacted the Institutional Review Board that was responsible for approval of the Ketec clinical trial, but the IRB allegedly did nothing to report the fraud and stop the use of Ketec. And now here we are again today. Research is the key to innovation and discovery, including curing deadly diseases. But, as this whole panel agrees, the research must be conducted ethically so that participants understand the risks and make informed decisions about volunteering. That's why we need to upgrade our entire patient protection system in this country. Mr. Chairman, I've introduced legislation in the last 6 sessions of Congress, the Protection for Participants in Research Act, and it reforms federal regulation and oversight of research on human participants by making federal regulations applicable to all research that is in or affects interstate commerce, that strengthens the education and monitoring of institutional review boards, that harmonizes FDA regulations and the common rule, the 2 major sets of federal regulations governing research participant protection, that strengthens protections against conflicts of interest by investigators or IRB members, that improves monitoring of research risks and reporting of adverse events and unanticipated problems. We have reintroduced this legislation this session of Congress, and I would urge every member of this subcommittee on both sides of the aisle to look at the bill and think seriously about co-sponsoring it. The last session of Congress, we came close to passing the legislation on the suspension calendar, because I think one thing we can all agree on in a bipartisan way is that we need to encourage medical experimentation, but we need to do it in a way that both protects the patients and gives them informed consent about what they're getting into. Mr. Chairman, I don't want to be here for 13 hearings like we have been on food safety. I want to get this done. We've been working on it a number of years. We know the problem. We know the solutions, and I'm looking forward forward to working with everybody on this committee to improving research so that we can have a robust system, but at the same time protect the participants. Thank you, Mr. Chairman.
Thank you. Mr. Burgess for opening statement, please.
Thank you, Mr. Chairman. And in a surprise move, I'm going to agree with the other side of the dais about the number of hearings, not wanting to have the number of hearings we've had on other areas before we do something. You know, today's economic environment, there's a lot of investigative activity that we could focus on, and we continue to have FDA-related hearings. I mean, this is the Committee on Oversight and Investigations, not the committee to investigate the FDA. But I believe this subcommittee has some jurisdiction in what's happened with the financial services in this country, and we've had no hearings on that. Secretary Geithner might enjoy a visit to our committee, and I'd enjoy having the opportunity to question him. So to the extent that this subcommittee has jurisdiction over the Troubled Asset Relief Program, I believe we ought to be involved. The Department of Energy. We had 2 hearings in this subcommittee last Congress on the security of our national labs. I recall us having questions for the head of the Lawrence Livermore Laboratory. Well, it turns out now he's just right down the street at the Department of Energy. When are we going to have Secretary Chu in to provide answers to those questions that we couldn't get answered last fall? Instead, we're having yet another hearing on the Food and Drug Administration relating an agency that we all know is in desperate shape, is broken, the morale of its workers is precariously low. We acknowledge it. We're part of the cause. It's a 20th century agency operating in a 21st century world, a world that's global, commercial, and innovative with regard to foods, drugs, and medical devices, but it's being regulated by an agency that is underfunded, understaffed, undersupported, and what meager funds we do provide them, they've got to expend preparing for the next congressional hearing. Now, these issues related to the institutional review boards are serious. Any human subject testing should be carefully overseen by the federal government to prevent abuses. The types of products that were being discussed in the issues before us today are products that I would have used in my or might have used in my former life, so I understand the seriousness of this issue. But I can also remember back right before I started medical school hearing about the experiments going on in Tuskegee, Alabama, and the former Department of Health, Education, and Welfare, and their involvement. That's why the government now has the common rule to govern 17 different departments and agencies within the federal government on human testing, and why the Food and Drug Administration has similar regulations governing human subject testing for medical devices and drugs. There must be ongoing scrutiny of the internal review boards. We must make certain that the science is unfettered and rigorous, and the Office of Human Research Protection needs to have the appropriate oversight. We need to make certain that we don't politicize the process, that conflicts of interest are being avoided, and all adverse events are thoroughly evaluated, and that there's a clear avoidance of the IRB shopping where an institutional review board will be removed from one institution to another because the results were not favorable. I am particularly concerned about the interaction of the common rule with the Food and Drug Administration regulations governing the investigation of new drug applications. We all know the failures of the IRB and KeyTech. Their failure was the impetus behind the GAO report being presented to us today regarding the review and oversight of the institutional review boards. But this is a problem that can be fixed. Let's fix it and move on to the next thing. We should hold a hearing on the entire approval process at the FDA. The IRBs, certainly they need to be investigated, the registration system, but what about the 510K exception for new drugs and the alleged revolving door where FDA employees go straight to the drug companies and then come back? We owe it to the American people, we owe it to the scientific community to fix the FDA and fix it right. Let's get on with that task. I yield back.
I thank the gentleman. I'd also note this week you addressed a letter to us on wanting to do hearings on medical devices and with the FDA, and that's something that we are looking at closely. So just so the record's clear, we'll probably have more FDA hearings, unfortunately. Ms. Christensen for opening statement, please.
Thank you, Mr. Chairman. This is a very important hearing, and I thank you, Chairman Stupak and Ranking Member Walden, for holding it. Because of the differences we have seen in response to medication and other treatments by African Americans, we, including the National Medical Association, who I see in the audience, have been encouraging individuals and providers in our communities to become involved in clinical trials. I even participated in one briefly before coming to Congress. But in our community, the specter of Tuskegee still looms large in our minds. And then there have been more recent incidents. I recall joining with other members of the House to stop the testing of pesticides in children, mostly African-American poor children, just a few years ago. So if we thought that this was an aberration or that Tuskegee could not happen again, obviously, as we tried to convince our community, the GAO report tells us that we were badly mistaken. The IRB process is supposed to ensure the health and safety of individuals in clinical trials. We who have apparently misplaced our trust in the system are outraged at the failures that are documented in the GAO report. The system needs to be fixed, and I, for one, cannot in good conscience encourage another person to participate in a clinical trial until it is. Thank you, Mr. Chairman. I yield back.
Thank you, Ms. Christensen. Mr. Gingrey, opening statement, please.
Mr. Chairman, thank you. Today, this committee has an opportunity to make sure that our institutional review boards are taking every possible step to ensure the safety of those who agree to participate in biomedical research. Biomedical research and clinical trials are critical to developing and perfecting the next generation of life-saving medicine and devices. Without question, the potential benefits must outweigh the potential risk to participants. However, these individuals must also be made fully aware of these potential risks when they agree to participate. Mr. Chairman, I look forward to listening to the testimony, and I'd like to reserve the balance of my time for questions, and I yield back.
Thank you, Mr. Gingrey. Mr. Green for opening statement, please.
Thank you, Mr. Chairman. I thank you for having this hearing today on the Institutional Review Boards, the IRBs, and the federal government's oversight of these boards. IRBs were created to protect individuals from harm or death during an experiment and ensure individuals give informed consent to the researchers. IRBs are in place to minimize the risk to the subjects that are the risk of the study are reasonable and in anticipation of the benefits. The protections for subjects during experimental research are vital. Unfortunately, we have two painful incidents in our past to remind us just how necessary these protections are. The formaldehyde distribution in 1960 and the Tuskegee study in 1974. Both these incidents serve as painful reminders of the wrongdoing of researchers at the expense of health and well-being of the subjects. Most recently, we have the KTEC incident, which the IRB failed to investigate whistleblowers' allegations during continuing application, review of the application. I was on this subcommittee when we investigated KTEC and the flawed review process that enabled the drug to come to market. Several deaths have occurred during studies that received IRB approval. In recent years, many call for reforms to the IRB system. IRB regulations were created in the 1970s and have not been reformed in recent years. Currently, HHS and the Office of Human Research Protections has the jurisdiction over IRBs for studies with federal funding. FDA has jurisdiction over testing for medical devices and drugs. HHS requires IRBs, but the FDA does not. However, the FDA is developing an IRB process. There are also independent IRBs not affiliated with any institution operating in the U.S. These IRBs are associated with the industry. The GAO and HHS have issued several reports documenting problems with the current IRB process. In 1998, GAO issued several recommendations for IRB reform, and to date, none of these recommendations have been adopted by HHS or FDA. I am looking forward to the testimony for witnesses today, and particularly the GAO, so we can see if our oversight of IRBs is adequate and whether reforms of the system need to be made. And I yield back my time.
Thank you, Mr. Green. Member of the subcommittee, Mr. Markey, opening statement, please.
Thank you, Mr. Chairman, very much. While legitimate research is vital, human experimentation must be conducted under the highest ethical standards. This is a very important issue to me. In November of 1986, as chairman of the Energy and Commerce Subcommittee on Energy and Power, I released a report describing radiation experimentations on human subjects by American scientists between the 1940s and the 1970s. The people tested in these experiments were used as nuclear human guinea pigs to determine the effects of exposing humans to nuclear radiation. Most of those experiments provided little or no medical benefit to the patients. In many cases, informed consent was not granted. Yet, these individuals were asked to ingest, inhale, or be injected with radioactive materials whose safety was not yet determined. These scientists recklessly endangered human lives, and much of their work was kept hidden from the public until the 1980s and 1990s. The good news is that although when I released my report in 1986, the Reagan and then Bush administrations refused to respond to it, President Clinton in 1994, upon my urging, established the Presidential Advisory Committee on Human Radiation Experiments, which issued this report, which led to the strengthening of regulations for research with human subjects. We are here today to discuss IRBs. IRBs is supposed to stand for Institutional Review Board. Unfortunately, with some experiments, IRB stands for irresponsible, reckless behavior. Unscrupulous IRBs have followed lax review procedures and unethical practices when assessing the safety of clinical trial experiments. As a result, participants have been put at risk of injury or worse, death. Without proper review from IRBs, the scientific integrity of clinical research work has been compromised. This can lead to faulty evidence regarding the safety of drugs and devices and can further endanger the safety of the public at large if these products gain approval by the FDA. When it comes to protecting the safety of consumers, we must have the highest standards. In February of 2007, when I called on the FDA through several of my letters and a hearing by this subcommittee, and again, Mr. Chairman, you've been a real leader on this, to answer questions regarding the safety of the antibiotic Keytec, the FDA approved Keytec partly based on fraudulent studies of its safety. Later, we found that Keytec is linked to severe liver damage and death. In this case, the IRB responsible for approving the clinical trials of Keytec ignored warnings from a whistleblower. Mr. Chairman, you have really been a policeman, a watchdog on this issue. This hearing is another in the long process that you have conducted, and I want to congratulate you for that. I yield back the balance of my time.
Thank you, Mr. Markey. Ranking member of the full committee, Mr. Barton, has joined us. Opening statement, please, Mr. Barton.
Thank you, Mr. Chairman. Apparently, I'm still in time to do the digital transition opening statement, too, if that subcommittee chairman is here for this hearing. I want to echo what Congressman Markey just said about your leadership and Mr. Walden's leadership on this issue, taking a look at the institutional review boards. We're following up today on an issue that was uncovered during an investigation in the last Congress. The question is whether these institutional review boards do a good job of protecting human subjects. When we started looking into this, we were concerned that some of the IRBs were not equipped to handle the amount or the complexity of the work that comes up during the clinical trials. As a part of our subsequent investigation was an undercover work that the GAO conducted over the last year. GAO made up a supposed clinical investigator, outfitted him with a transparently suspicious resume, assigned him a fake medical license number. GAO also concocted a verifiably false company, Device Med Systems, as the sponsor of the fake study. The study protocol was straight from the Internet, and the device, the company, and the doctor were 100% fictitious. Once this particular IRB learned the committee was investigating, to their credit, it took them less than a day to decide that something was wrong. But instead of actually doing something, they put out a news release that acted as if they had just been stung by James Bond instead of the GAO. The IRB is here today to explain why it decided to approve the equally easy to detect fake protocol and whether it stands by that decision. I suspect that this subcommittee will have some very direct questions about the alleged science in the patently false protocol that Coast IRB rubber stamped, and why it caused no apparent concern even though it had no supporting data from clinical trials, and the study device matched examples of significant risk devices on the FDA's own website. I think we should be careful not to overemphasize or to underemphasize the significance of what this investigation has showed. Coast IRB was sloppy and or negligent, perhaps just flat wrong, in its judgment about the protocol and the risk that posed to its study subjects. But fortunately, 2 other IRBs that were presented with the same protocol rejected it, one without even considering it. The vast majority of clinical trials, at least I hope, are conducted without harm to patients. Even so, I'm bothered by the fact that 2 of the IRBs that GAO investigated and the other IRBs who advertised in trade magazines and on the Internet seemed to focus on the speed of their review and the guarantees of a quick turnaround time. In some of those ads, patient protection and safety seem almost like an afterthought. The bigger issue today may not be that one IRB made a grave error and then tried to throw attention elsewhere, but that the current set of regulations does little to prevent such an error. That's our job if we need to review those regulations. We need to take a close look at those regulations and ask whether they are meaningful in the current research and clinical trial environment. Current regulations require that an IRB must make a number of determinations before approving a protocol, including that risks are minimized to the patient if the patient has knowingly consented to participate in the study. But as GAO and the HHS Office of Inspector General reports have been reporting for years, there is basically no test that an IRB must pass before it opens for business to show that it's qualified to review such clinical trials. It's frustrating the same problems keep popping up. These are problems that the GAO and the Inspector General have discussed in reports issued as long as 10 years ago. I know that the FDA recently announced a rule that will require IRBs to register with the FDA, but again, that was a reform that was called for years ago. And I don't think that this rule would have made much difference with regard to solving the problems that GAO has identified in its most recent undercover investigation. By putting the GAO findings in proper context, we can strengthen biomedical research and innovation. If the public sees that our committee and federal agencies are ensuring that the research committee is looking out for the folks here, confidence in clinical trials will be boosted and participation will increase. This should be a very meaningful hearing if we keep our discussion in perspective. I want to thank our witnesses for testifying today, and again, you, Mr. Chairman, and Mr. Walden, for leading on this issue. I yield back.
Thank you, Mr. Barton.